Good morning, I'm John Brand. I'm a director at Bowman Gilfillan and a specialist in alternative dispute resolution. I spoke this morning at the Leadership Angle at the University of Stellenbosch Business School on King 3 and alternative dispute resolution and indicated what we need to do in order to comply with King 3 and to keep ourselves in line with the developments in the rest of the world, which in essence is one in which almost all commercial disputes go to mediation before they go to court. An edited version of my talk is available on the University of Stellenbosch Business School website. The topic which you will see is on business leadership, dispute resolution and King 3. As we will see, King 3 recommends that as an aspect of good corporate governance that directors utilize appropriate dispute resolution. And the focus of my address this morning is going to be on one of those processes which King mentions, which is mediation. Turning first to King 3, that is all that King 3 says. In the chapter on dispute resolution, it says the board should ensure that disputes are resolved as effectively, efficiently, and expeditiously as possible. The board should adopt formal dispute resolution processes for internal and external disputes, and the board should select the appropriate individuals to represent the company in ADR. So very unspecific, but nonetheless very important, because it's the first time that a corporate governance duty to consider methods of dispute resolution other than litigation has actually been legislated, if I could put it that way. Mediation is a voluntary process in which a mutually acceptable third party helps the parties to a dispute to try to reach an agreement. And a couple of features of that definition are very important. The most important one is the final wording there is that it is a process in which the third party helps the parties to try to reach an agreement. It is not an adjudicative process. The mutually acceptable third party is very, very important because there are aspects of the mediation process which are highly confidential, and if you can't trust the mediator to maintain that confidentiality, you're not going to open up to the mediator, and the mediator isn't going to be able to help you very much. Really what the mediator does, very briefly, is to engage with the parties, usually at the beginning in a joint session, hearing what the dispute is about, but quite quickly separating the parties and going to side and confidential side meetings with the parties, where you hear what their deepest and darkest secrets are. You try to discover what the underlying cause of the dispute is, what business interests they have, what kind of solutions they're looking at, what their alternatives are, what their fears and concerns are. You store that in your mind. You go next door, you hear a very different picture from the other parties, and you start to see where there are synergies between the parties. And what's wonderful about the process is, unlike the litigation process that I've been involved in most of my life, where you are looking backwards at what people did right or wrong 3 years ago and determining who is right and wrong according to Grotius, Foote and Van den Hoeven, you now saying what business opportunities are there going forward that we can trade in order to get rid of the past fight. And so you find future-looking solutions based on business imperatives. What you will see is that there has been an enormous change in the rest of the world, and we need to just ask ourselves, why has that taken place? And it's these kind of stats which I think underlie it. A 2006 study revealed that conflict in British business costs some £33 billion. What people often mistake when they cost the cost of business conflict, they think only of what they're paying the lawyers. They don't think about the amount of executive time and managerial time that is spent in the preparation of a 3-year, 4-year piece of litigation. Let's just have a look at problems with litigation and arbitration. The first is delay. US research shows that even arbitration takes an average of 16.7 months from the filing of a complaint to an award. The court delay, I don't know what it is down here in the Cape, but we can't get a hearing in Johannesburg inside 3 years. Expense. I love this quote from The Economist. The Bank of Credit and Commerce International's lawsuit against the Bank of England lasted 13 years and cost £100 million in legal fees. The Bank of England's governor disgustedly described it as, quote, the most expensive fishing exercise in history. Mr. Justice Tomlinson called it a farce. Had the parties agreed to mediation, it would have taken probably a day and cost just a few £1,000s. We have a wonderful process called ARB-MEAD, which is a process where you first put on your hat as arbitrator, you hear the evidence, you hear the legal argument, you make a decision, you write your decision as though it is a judgment, but you don't hand it to the parties. You put it in an envelope, you seal the envelope, you put it on the desk, and you say, okay, the adjudicative process is now over. I'm taking off my adjudicator's hat, I'm putting on my mediator's hat. Now let's see if we can find a sensible solution to this problem. You then go into normal mediation and you explore all the financial and business interests, and you then, if you reach a solution, you tear up the adjudicative outcome and nobody knows what it is. If you don't, you open the envelope and people get the adjudicative outcome. Unpredictability, and I don't have to say to business people the discomfort of unpredictability. Also win-lose outcomes. And again, if you contrast what's in the envelope, which is always a win-lose outcome, with the win-win mutual gain type outcomes that you get in mediation, it's very, very stark. Also harm to relations. I mean, you can't resolve a dispute between ongoing shareholders, between executives and the board, where they have to work together tomorrow by the litigation process. Access to justice. If business people find it difficult to spend 3 years or 13 years wending their way through the court, think about the average man on the street. Publicity, a lot of corporate disputes you prefer to deal with privately. Let's turn to the advantages of mediation against that background. Firstly, speed. CEDA, which is the Centre for Dispute Resolution in the UK, probably the leading dispute resolving body there, estimates that of the plus minus 3,000 commercial disputes mediated in London each year, 70 to 80% are settled within 1 or 2 days, and a further 10 to 15% within a few weeks. Even if your mediation takes you 3 days with the most expensive mediator in the country, which may be 20,000 Rand a day, it's going to cost you 60,000 Rand divided by the two parties is 30,000 Rand. Compare that with what you're paying your lawyers. Positive impact on relationships. Creativity. One of the things we do as mediators is assist the parties through brainstorming and the like to say, okay, we now understand the problem. We've got a good idea of the problem. Let's brainstorm every conceivable solution without evaluating those solutions. Let's get them all down and then let's see what combination of those solutions is the most creative way forward. Addressing of underlying needs to really understand what needs are. Addressing of underlying causes. I mean, one of the other things that has frustrated me as a lawyer is that we so often deal with the symptoms of conflict. Management of complexity. Law tends to simplify, whereas business relationships are actually very complex. Delivering mutual gains outcomes. Instead of trying to find outcomes where one party wins and the other party loses, is to say, how can we find an outcome which is of maximum value to both parties at the same time? Bridging mistrust, bridging poor communication, bridging lack of skill, and then success, generally an 80 to 90% settlement rate inside of 2 or 3 days. Let's just have a look at what's happened in the United Kingdom. In 1999, Lord Wolfe, who was the Chief Justice there, was given a commission to examine why the hell it was that it was taking business people 5 years to get to court in London. And he made very far-reaching recommendations. Case law had a major impact. The rule change had a major impact. The government pledged that it would not go to court on any matter in which it was involved without first trying mediation. They introduced as an ethical duty on all lawyers that you had to advise clients of all of the benefits of mediation. Business support from the CBI and 80 major companies. 220 law firms gave support to it and undertook that they would support it. The United States, very similar. In Europe, all of those countries have very active mediation. There's emerging mediation in those countries. They're largely the kind of Eastern Bloc countries. And in Asia and the Middle East, as I think many of you know, there are well-established mediation centers.